ল ব্যারেট রেজিস্টার্ড আইনি প্রতিষ্ঠান। আমরা সুপ্রিম কোর্ট, হাইকোর্ট, জেলা কোর্ট, ক্রেতা সুরক্ষা আদালত প্রভৃতি কোর্টে যে কোনো আইনি সমস্যায় সারা ভারতবর্ষ জুড়ে আপনাদের পাশে সবসময় সর্বদা। ল ব্যারেট ল ফার্মের তরফ থেকে আজকে যে ভিডিওটা দেখানো হচ্ছে সেই ভিডিওটা আপনাদের পুরোটা দেখার জন্য অনুরোধ করা হচ্ছে। আজকের বিষয় হলো সেকেন্ড ম্যারেজ ভ্যালিড হবে, যদিও সেই যদি দেখা যায় যে সেই কেস মানে ফার্স্ট ম্যারেজ ডাইভোর্সের জন্য কেস চলছে, সেইরকম অবস্থাতেও সেকেন্ড ম্যারেজ ভ্যালিড, এর উপর একটা বিশাল জাজমেন্টও হয়েছে। সেই বিষয় নিয়েই আজকের এই আলোচনা। তাই জন্য অনুরোধ করা হচ্ছে পুরো বিষয়টা দেখার জন্য, স্কিপ না করে। Second marriage valid even if divorce plea of first marriage pending in courts, Supreme Court of India decision. Supreme Court rules that if both parties from first marriage have amicably parted but case pending in court, then second marriage still valid. New Delhi, the Supreme Court has clarified that a second marriage is valid even if a divorce proceedings of the first marriage are pending in court, provided that both parties from the first marriage have amicably parted and have decided not to contest the decision. Interpreting the Hindu Marriage Act, Justice S.A. Borde and L. Nageshwara Rao, however, said the dissolution of the marriage is complete once the court finalizes the order, subject of courts to appeal. In case of dissolution of marriage, a second marriage shall be lawful only after the dismissal of the appeal. The apex court's judgment came on a plea wherein the second wife contested the marriage with her husband on the grounds that it took place before the appeal of his divorce was finalized. The husband had appealed against his first divorce in the Delhi High Court. He, however, settled the dispute with his first wife and filed an application to withdraw his appeal on 20th November 2011. Before the court could formally rule on the plea, the man married for the second time on 2nd December 2011. With his other marriage too running into trouble, his second wife took him to court claiming that their marriage was null and void as it had taken place during the pendency of proceedings of his first divorce. Ruling on the plea, the two-judge bench said that man's intent was clear from his application. After entering into a settlement with the first wife, he, that is the husband, did not intend to contest the decree of divorce. His intention was made clear by the filing of the application for withdrawal. It cannot be said that he has to wait till a formal order is passed in the appeal or otherwise his marriage dated 6/12/2011 shall be unlawful. The court said, therefore, the court ruled the appeal is deemed to have been withdrawn on 28 November 2011, the date he filed the application. It added that on 6 December 2011, the date of his second marriage, the first wife cannot be considered as a living spouse. Hence, Section 5(1) is not attracted and the marriage between the second wife and the husband cannot be declared as void. The apex court said the dissolution of the marriage is complete once the decree is made, subject of course to appeal. This court also decided that incapacity for the second marriage for a certain period of time does not have the effect of treating the former marriage as subsisting, and the express spouse would not include within its marriage meaning the expression former spouse, it said while relying on its 1978 judgment. Hindu Marriage Act, a social welfare legislation. The Apex Court further said that the Hindu Marriage Act is a social welfare legislation, and as such it cannot interpret such as laws as though they were cast in stone. The Hindu Marriage Act is a social welfare legislation and the beneficent legislation, and it has to be interpreted in a manner which advances the object of the legislation. The Act intends to bring about social reforms. It is well known that this court cannot interpret a socially beneficial legislation on the basis or as if the words therein are cast in stone. Rao, who authored the judgment, said it would thus appear that the law is already settled by this court that a marriage contracted during a prescribed period will not be void because it was contracted under an incapacity. Obviously, this would have no bearing on the other conditions of a valid marriage. The bench said, in any event, in the present case, we are satisfied that the appellant's marriage was not subsisting when he married again. He had filed an application for withdrawal of his appeal against the decree for dissolution and had done nothing to contradict his intention to accept the decree of dissolution, Bode said in a separate concurring judgment. থ্যাংকিং ইউ অল, লবারের তরফ থেকে আপনাদের সবাইকে অসংখ্য ধন্যবাদ ভিডিওটা দেখার জন্য। ভিডিওটা ভালো লাগলে অবশ্যই লাইক করবেন, সাবস্ক্রাইব করবেন চ্যানেলটা এবং প্রচুর শেয়ার করবেন যাতে করে অন্যান্য দেখার সুযোগ পায় এবং উপকৃত হয়। এই সংক্রান্ত কি অন্য বিভিন্ন বিষয় সংক্রান্ত যদি জানার আপনাদের থাকে কিছু, তাহলে অবশ্যই কমেন্ট বক্সে কমেন্ট করুন। আমরা সেই কমেন্টের উপর ভিত্তি করে আমরা তারপর ভিডিও বানাবো। আইনের উপর যা করা যায় তাই উপর ভিত্তি করে আমরা অবশ্যই আপনাদের বিষয়ের উপর চিন্তা করে ভিডিও বানাবো। ধন্যবাদ।